Thank you so much, Media Fraternity, for coming. And I'm the chairperson, Nagaland State Commission for Women. And here with me is my advocate, Advocate Rinda Grover from Supreme Court, Senior Advocate. So, the Nagaland State Commission for Women, we are happy that you are here. And as we all are aware regarding the ongoing cases, so to that, first of all, I would like to applaud and appreciate the Nagaland State government also for taking the step by suspending the alleged accused, and also we also would like to thank the civil society and the public in general for their support. So I don't have much to say. I have my legal advocate here. She will be speaking on the other important laws which we need to be and aware about. So please, my advocate.
Thank you, Chairperson. Good morning, everyone. As I've been introduced and as you may be aware, I have been engaged by the Commission to represent them before the Honorable High Court of Nagaland, where we appeared yesterday in the Kohima High Court. We are, of course, speaking in the context of an ongoing investigation, a case in which the Nagaland Women's Commission has played a sterling role. And the reason I say that, this is a case under investigation, so I will not be going into any details because that is for the police to investigate and for the police to then place the charge sheet before the competent court. However, Nagaland Women's Commission did play a role in the issue coming to light, as there were quite a few women working within IDAN who informed them of the sexual harassment that they were facing at the hands of the accused who's under investigation, Mr. Reny Wilfred. Why does a statutory body like Nagaland's Women Commission step into the situation? In my legal practice now of over 30 years, I have represented many women and other vulnerable groups and marginalized sections in their struggles for justice. If I were to focus on what I have learned from my experience as a lawyer, particularly on issues relating to sexual violence against women, we know that despite the law today having many provisions that prohibit any form of sexual offense, be it sexual harassment, molestation, outraging modesty, disrobing a woman, rape, gang rape, everything stands prohibited and penalized under Indian law. Many of the changes, as you all may be aware, took place in 2013 post the Nirbhaya incident in Delhi. Yet, what we do know, and we know this from our personal experience and from our professional experience, women continue to face a lot of sexual violence. And the sexual violence, as I said, is a range. It is very commonly misunderstood that when we talk about sexual violence, we are only talking about rape. That is, to my mind, a completely wrong reading and understanding of the law. And that I would go so far as to say that this confusion is deliberately created so that we are not aware of our rights. Sexual harassment is about the dignity of a woman. And that is what, in 1997, in the Vishakha judgment, the Honorable Supreme Court said there should be a way to address the misconduct of sexual harassment. Following the 1997 Vishakha judgment, all workplaces across the country, be a government office, a private office, a school, a college, a university, even a court, a private office, everybody was required as per the Supreme Court guidelines to have what was called an internal complaints committee. We know that most places did not actually act immediately post the 1997 judgment. Then we had the 2013 law, what is commonly called the POSH law, which is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, which codifies what the 1997 judgment said. In 2013, as I mentioned, there were amendments made to the sexual offences laws relating to women, when sexual harassment was made a criminal offence also under the then Section 354 capital A of the Indian Penal Code. We now know that the three criminal codes have been now replaced by the Bharatiya Nyaya Sanhita of 2023. Under the Bharatiya Nyaya Sanhita, the laws have been, these offences continue to exist in our statute books. The number of the offences has changed. We now have sexual harassment as Section 75 of the Bharatiya Nyaya Sanhita. So sexual harassment is not a minor thing. Sexual harassment is not what we used to say in the, and maybe we still use this phrase called eve teasing, which I think is a terrible, terrible vocabulary and we should discard it. There is eve teasing gives the impression that, oh, it's something minor, something mild, something fun, or what in Hindi is called chhed chhad. And that is how we dehumanize and trivialize the offense of sexual harassment. The correct phrase is sexual harassment, which goes to the heart of the dignity of a woman and is both a civil misconduct which can be remedied under the POSH law, and the duty is on the employer to provide a safe, sexual harassment-free workplace. It's a statutory duty and a constitutional duty. And we have sexual harassment as an offense under the Bharatiya Nyaya Sanhita. What comes within sexual harassment is a range of conduct. It can be a sexual colored remark. It can be a request for sexual favors. It can be an unwelcome physical contact. It can be explicit sexual overtures. Any of these constitute sexual harassment. And I think that what the Commission is actually doing is to, in furtherance and in commitment to its mandate, which is to ensure that women's dignity, women's rights are promoted and safeguarded, the Commission is taking forward both a specific litigation, which it has handed over to the police, which is the agency to investigate any crime, but the Commission has also, therefore, through this work, is taking forward what continues in India, in many parts of the country, to be a law that is about which very little is known. And I think in my conversations with the chair and other Commission members, I don't think that there are today in all institutions, government and private, the Internal Complaints Committee, which was the mandate of 1997. We are now in 2025. How come a Supreme Court guideline and direction which is binding is not being adhered to, not being followed? Does this tell us something about how we treat women, how we look upon women, and how we think sexual harassment is something minor and why make such a fuss about it? And that is why you need the Commission to step in and bring the issue into focus. As far as taking forward what was just addressed by the chair, yes, there has been a suspension order, which is actually what the law mandates. There is nothing exceptional that has happened. In my experience, again, in my professional experience, and I am aware and informed because I had, in my professional capacity, been engaged with the Nagaland matter also, the POCSO prosecution that this very same accused Reny Wilfred is facing. To my knowledge, and I would be very happy to be informed otherwise, Mr. Wilfred was not suspended despite him facing a POCSO prosecution where 2 minor girls have been sexually abused. This is very, very extraordinary. This never happens. A civil servant facing a criminal prosecution involving sexual abuse of 2 minor girls is not suspended by the government. There are conduct of service rules which guide all civil servants across the country. These are offences which involve moral turpitude. These are criminal offences. Surely the government does not in any way think it's appropriate to allow this kind of, and this is not misconduct, this is criminal conduct. Surely the government does not think that criminal conduct which impacts lives of women and girls should go unaddressed. And now you have a situation where quite a few young women have complained of sexual harassment by the same Mr. Wilfred. And this time round, as was said by the chairperson, the government has acted in accordance with the law, policy and rules and suspended Mr. Wilfred. One does, however, think aloud that if such steps were taken earlier, would this impunity have been checked? Would this kind of crime not have been repeated and recorded? These are things that do crop in one's mind, and so one wonders whether if at that moment, in accordance with law and policy, the government had acted, could other women's dignity have been safeguarded? I do, however, want to point out here that the suspension order, and I'm sure you all have seen it, the suspension order, if I may just pull it up, the suspension order does not specify and notify the offences under which he is being investigated. Usually, in ordinary course, including in suspension orders that I have seen of the government of Nagaland, and these, I just want to remind that I know Nagaland enjoys special status under the constitution, which is important, but the civil servants, particularly the IAS officers, are governed by conduct of service rules, which are all India service rules. They are not peculiar to any state. This suspension order is completely silent and does not tell you what are all it says, and I'll read it out. It's obviously by the Chief Secretary of the government, that the undersigned in exercise of power places Shri Reny Wilfred IAS under suspension with immediate effect. It's dated 21st of May. It says, whereas a case against Shri Reny Wilfred posted as Joint Secretary Finance Department in respect of a criminal offence is under investigation. Why is it not specified what is the nature of the criminal offence? After all, that there is an FIR. An FIR is a public document. FIRs of sexual offences are not put on the website to protect the identity of the women, not the identity of the accused. Usually in the ordinary course, FIRs, suspension orders will specify the sections under which the FIR is lodged, which are the relevant sections due to which the suspension has been given, are Section 74 of the BNS, which is assault or use of criminal force to a woman with intent to outrage her modesty, sexual harassment, Section 75 BNS, and Section 79, which is word, gesture, or act intended to insult modesty of a woman. I think it's important that documents where the government takes actions, and rightly so takes actions against civil servants who may have, and I say may because the matter is under investigation, who may have abused their position and authority to commit sexual harassment or other offenses against women. The suspension order must notify these. We should not in any way even be seen. So in law we have a phrase, we say justice must not only be done, but must seem to be done. So when a suspension is given, it must not appear to the people that there is some effort, some way in which the person being investigated, and actually in this case being prosecuted as we speak under POCSO, is in any way being shielded, protected, or being given differential treatment, special treatment. That would be very important, so that the victims are assured, the women of Nagaland are assured, the girls of Nagaland are assured that the state will stand by the victim and ensure that justice is done for them. And therefore, it is a very difficult path that these women have chosen. As I said, I've represented many women, including in very high-profile cases against men who have sat in the highest offices of this country. Those women, when they raise these issues, are isolated, defamed, maligned, socially, threatened. All manner of backlash takes place against women who complain of sexual offenses against men in positions of power and authority. There is a pattern. It's not peculiar to this case. There is a pattern. Those women have an extremely difficult time, and therefore it is even more important for the Commission to have to step in, because this is not a battle that young women will be able to actually call out the impunity with which sexual offenses against working women is conducted. And yes, those women will be badmouthed. Their character assassination takes place. A lot of conversations take place in the social circle, where unfortunately men and women speak about how great and good the man is. I remember doing a case once for a woman who was a law intern against a man who was sitting in a very high office. He even put affidavits of his gardener to show he's a very good man. So let's understand sexual harassment. Sexual harassment can be committed by a man who may be a very great lawyer, a very great author, a very great painter, a politician, or a very competent officer. There is no issue over there. It's not as though a person's competence comes in the way of him being a sexual harasser. You can have both in the same man. And there is enough evidence of this. These are documented cases of our own and across the world. We have all heard of Mr. Weinstein, the most celebrated Hollywood producer. So competence and efficiency and intelligence don't come in the way of a man committing sexual harassment. Often we are told, oh, but he did not rape X woman. He did not commit sexual harassment of Y woman. Is it anybody's case that anyone who commits theft or murders one man should have murdered all men? Why am I saying this? Because there is such confusion and misinformation deliberately, knowingly spread about the offense of sexual harassment. We have to understand the nature of sexual harassment. Sexual harassment, and I am now quoting the Supreme Court of India, that every act of sexual harassment is a violation of the fundamental right of equality and dignity of a woman. Sexual harassment is an exercise of power. It takes place within an ecosystem where power can be abused. And therefore, these issues have to be understood and addressed decisively and sensitively. The Supreme Court of India in 2019 gave a judgment called Spruti Badade versus State of Maharashtra and others, in which they laid down guidelines and directions for every high court. And I'm talking of the judgment came on January 11th, 2022. It's a judgment of the then Chief Justice, Dr. Honorable Chief Justice of India, Justice Chandrachud, in which there was a direction given to every high court to set up a vulnerable witness deposition center in every district of this country. I would like to ask the media persons present here, do you have vulnerable witness deposition centers in Nagaland? What is the purpose of a vulnerable witness deposition center? It enables the witness, the victim, to give evidence without coming in direct physical confrontation with the accused, because there is an asymmetry of power. There is a power imbalance between the victim and the accused. And these are Supreme Court guidelines. These vulnerable witness deposition centers should have existed in every district of Nagaland. And the trial court decides, yes, these women, and it's not just for women. It can be anyone. It can be a worker who has made a complaint against a big employer. It can be a child. It can be a woman. It can be a poor person. It depends. It can be a victim of an atrocity by the police or the security forces. Any one of them can access the vulnerable witness deposition center. To my knowledge, after discussion with the Commission, we do not have in Nagaland vulnerable witness deposition centers in every district of Nagaland. I don't know if there is one in any district of Nagaland. Not to my knowledge, but I can be wrong. You are better informed than me. In these circumstances, we need to locate and understand these offenses that we are discussing. And if these offenses are to be checked, if violence against women is to be diminished and to be stopped, and not just by slogans, it will not go away with slogans. It will not go away with just saying things on billboards. When it comes to individual cases, when it comes to cases by people we know, that is when the challenge comes. That is when we have to let the agencies perform their task, the courts perform their task, and give the support that the law gives to the women for these cases.
Coming back to yesterday's...
Can we switch off this AC? Yes.
Coming back to yesterday's hearing in Kohima, the Kohima bench of Kohima High Court, I reckon there must be a limit to what extent the law allows disclosure of information relating to an ongoing investigation or court hearing. However, if you kindly let us in on what was the nature of the hearing yesterday.
Sure. No, there is no. Yesterday's hearing was available. It was an open court, so there is no secrecy about yesterday's hearing. The hearing before the High Court was in an open court. Anyone, and in fact, since now it's in hybrid mode, anybody can watch. Yesterday's hearing was relating to a petition, a writ petition filed by accused Mr. Wilfred, where he is seeking quashing of the FIR against him. The FIR dated 2nd of April, which is under investigation. And he had sought an interim prayer that the investigation be stayed. We have already filed our reply as commission before the High Court, as has the state. It was his counsel who took time yesterday, I'm informed by the junior, as what he said to the court, was that the senior counsel had some personal bereavement and the senior counsel did not come to court to argue the matter. We were ready and we are ready to argue the matter. As we have stated in our reply filed on behalf of the commission, this is not a case for quashing of the FIR at all. The law on quashing is very clear. It is settled by the Supreme Court, and this particular FIR does not fall within the parameters of that. But that will be argued as and when the next hearing is now on 22nd of July. And what I did point out to the court is that on 6th, by an order of 6th May 2025, the commission was impleaded as a party. Prior to this, the petitioner named 3 of the members of the commission as individual respondents. I think that is totally unwarranted. It is not, it's actually improper, it's improper in law, and it's inappropriate even otherwise. And it is quite clear that this was perhaps a desperate attempt by Mr. Wilfred to individually intimidate members of the commission. I think by now it would have become clear that the commission is not feeling intimidated and is standing strong, because the commission is serving a statutory purpose. It's a statutory obligation they are performing, and these kind of tactics I don't think will work well in a courtroom. But we will argue the matter on 22nd.
Yes, ma'am. We heard that you have contributed in drafting 2013 Criminal Law Amendment and Protection of Children from Sexual Offences Act 2012, where you have also highlighted, you addressed the Nagaland case 2021, where Reny Wilfred has sexual conduct case against 2 minors. Now, where the government of Nagaland Chief Secretary being the head of the administration. Now, there was a lapsus from the Chief Secretary's office that he was not suspended. So in that regard, if any administrative head makes mistakes, what does the law say about that?
Well, I will not go into what should happen with the then Chief Secretary. The POXO case is quite old now, if I remember. What is the year of the incident? I can't...
2021.
2021. All I can say is that, what do we understand from that? How can a senior IS officer, and it's not just a case where, of course, he's innocent till proven guilty. Nobody is saying punish a man without due process or without fair trial. But we are saying, and the law says it, I have not said anything today or will say anything ever which the law does not say. What we are saying is that the law, for a reason, says that if a person occupying a government position is being prosecuted for a criminal offense, then the person needs to be suspended during that period. Why does the law say that? For few reasons. One, such a person obviously is not for that time period fit for the job. Performing a job, a government job, is not only about signing papers, being efficient in building roads, being efficient in doing projects. That's not all that a government servant is doing. A government servant is engaging with a large number of people, is a representative of the government, and therefore has to carry certain principles with them. Secondly, when you sit in a government position, you have access to power, you have access to resources. Those two minor girls, because I have read the file since I was consulted in that matter, come from an extremely impoverished family. The reason they were working, minor girls, working in the house of a civil servant, which in itself, if we have forgotten, there is a child labor prohibition law. Two minor girls working as domestic servants in the house of a civil servant. What can be a greater power difference between the two parties? And yet, no suspension took place. This actually reveals to me perhaps the clout that he enjoys, and that is very worrisome, because the reason a person is suspended so that he has no access to be able to misuse this power. And because that suspension did not take place, I think it's a moment of reflection for the government of Nagaland, because these women who have now come out with very serious complaints of sexual harassment and other misconduct and offences, their dignity, their indignity, their harassment could have been prevented. And therefore, while Mr. Wilfred is being investigated, the government of Nagaland definitely needs to reflect and perhaps apologize to these women that they had to suffer this because of the serious lapse. And the rules have been broken. For what reason? Because those two girls are very poor? Is justice now going to be delivered depending on who is powerful, who is rich? Is that what the rule of law is? Surely special status does not mean Nagaland is allowed that.
Because, as we look into this POCSO special court, so I have a specific timeline.
Yes.
6 to 1 year.
Yes.
Now it's been delayed.
Yes.
So in that regard, well,
This is what happens when people occupy positions of power. Yes. This is how power plays out. All sexual offences are abuse of power. That is why I'm saying it's a moment of reflection for Nagaland government and for Nagaland society to stand up with the victims when they need the support.
so
I know Naga Mothers Association is supporting them.
So, ma'am, how do you ensure that the voices of the victims are not lost in the technicalities of this legal procedures?
Well, I think there are various ways to do it. One, we need to, the commission perhaps could undertake a series of trainings, because it begins with awareness, it begins with knowing, it begins with lawyers having skills, it begins with prosecutors being trained. In POCSO courts, I speak from my experience in Delhi, the prosecutor in a POCSO court, as per law, is required to have a special training. Every police station in a district, in every district at least one police station, is required under POCSO to have a special juvenile police unit. Again, people who are specially trained under the POCSO law, because we are dealing with very vulnerable children who, if the law will not protect, then what is it that we are trying to do in the country?
I think we also need a comment from the chairperson of the Women Commission. So I just want to draw a parallel between the ongoing case and the one in Nagaland. So in the case, in Nagaland's case, I mean, involving the officer, IS officer Reny Wilfred. Like Advocate Grover said earlier, he was not suspended by the government. Yet in this case, he was. I mean, the government was quick to suspend him, place him under suspension. What could be the reason for this? This is to the chair.
I think that question should be addressed to the Chief Secretary.
That's what I was about to
Yes.
respond here, because the question has to go to the state government, to the Chief Secretary. I don't have any comments on that.
And just on quick, the FIR is of 2nd April. The suspension order is of 21st May. I'm not sure that's quick.
I mean, speaking of the government bureaucracy, it's slow.
I don't think suspension orders wait like that at all. Suspension, that's not how bureaucracy works. These are questions for the Chief Secretary. Media should ask him.
So, ma'am, you have clearly highlighted everything and related to it, but then what would be your primary legal strategy in advocating for these victims in this case?
We'll wait for the charge sheet. Before the charge sheet, as I said, I'm not prejudging anything. Even in the Nagaland case, I will not speak because there's a trial going on. We have to wait for the charge sheet. Let the charge sheet come, and then the trial will begin. I just hope that, and that's why I'm stressing on this. See, these cases are fought as much, in my experience, inside the courtroom as much outside the courtroom. The women are under immense pressure. Socially, I am informed of that by the Commission. The Commission is being brought under pressure through all manner of social conversations that are taking place. I would urge society.
Yeah, with this, I would like to urge and appeal the society that at this time of, when the victims need the support, I really appeal our civil society to come out and support the victim at this hour. And also to know about the law, about whatever law is needed to protect the women and the child in the society. So, this is what I would like to.
Yeah, last question to Ma'am Robert. You have highlighted awareness to the general public, but when it comes to sexual misconduct or abuse to any minors or adult related to women, what is your general advice to the general ladies here in Nagaland? Because one time in India, it was considered as the safest state for women in India is Nagaland, but it doesn't look like anymore. So what is your advice to the women of Nagaland?
I think, sexual offences take place everywhere. I'm afraid that's a very sad state that we experience in many parts of our country. I live in Delhi. We know what goes on there. What I would say is that whenever such a thing happens, we must support the victim to see if they want to take forward the complaint. The commissions need to play a prominent role here, and courts need to be very vigilant, very prompt and effective. As you've already pointed out, the Nagaland trial is ongoing now for long. The longer these things drag, the more difficult it becomes for the victim to sustain. These are very difficult ongoing battles. Of course, the state prosecutes, but both competence and some kind of confidence building takes place. And if you have judgments, if you have verdicts where people are punished, it gives further confidence. And only then will this impunity break. For starters, I would say, are there internal complaints committees in all the government institutions, public sector, private universities, colleges, offices? Let's do an audit. The commission can do an audit. Is there, what is the timeline that it is taking place for sexual offences trials? Is there a vulnerable witness deposition center? These are all legal mandates. Just an audit of where the gaps are. And then you see to give victims confidence, you have to make the system accessible, sensitive. Only then will victims come forward. Otherwise, it is very difficult. Thank you.